really appreciate everybody being here. We have an interesting day in front of us, I think. I will let everybody know right off the bat, we will not be meeting tomorrow, but I'll let you know at the end of this meeting how we're going to try and make up that time. So I'll try to make a little bit of a plan. But we are going to go ahead and have the hearing on 2371 first. I know there's a lot of people that are here for the other bill, but I have been assured that the proponents and neutral who are here for 2371 they understand that we have a lot of other things going on. So we just so everybody knows, we have already gotten a preview on that bill. If the committee remembers, we had the informational hearing last week on the LLC Act. And so we're going to go ahead and take care of that one first, so everybody knows. So, okay, I will open the hearing on 2371, and we will get a bill brief from our reviser, Jason Thompson.
Thank you, Madam Chair. As you mentioned, Jason Thompson, Reviser of Statutes Office. You have a fairly lengthy bill brief, and I know you've had a lot of background on this bill, so I'll try to just hit the high points here. House Bill 2371 amends parts of 3 acts in current law. The first is the Kansas Revised Limited Liability Company Act. The second is the Business Entity Transactions Act. And the third is the Business Entity Standard Treatment Act. There are 2 new sections added at the very beginning that would be added to the Kansas Revised Limited Liability Company Act. The first one is about documents and electronic signatures, and I know you got a lot of background on that being added, so I'll just tell you that's in Section 1. Section 2 is the one about subscriptions for an LLC and issues related to that, whether they're irrevocable or revocable, and that's in Section 2. Sections 3 through 23 all amend statutes in the Kansas Revised Limited Liability Company Act. There's a little bit of detail about each one in the memo or the bill brief, and then I know there's more detail in the proponent testimony, so I won't go through all of those. At least I gave you a kind of a roadmap, so if you're looking for a particular provision, you might be able to find it in the bill brief. It starts with definitions in Section 4, and then it moves into more amendatory pieces after that. Skipping then to the next big chunk of issues that I wanted to highlight for you, section, because I know it was at issue in at least one other bill that you have in your committee. Section 16 is where the series limited liability company section is. That's KSA 17-76, 143. So if you want to look for that section, that's section 16 of the bill. Then there's a chunk of statutes in sections 20 through 23 about statutory public benefit limited liability companies, which some of you may remember from a few years ago, those public benefit LLCs. Some changes to those. And then the last 2 pieces are sections 24 through 29 are in the BETA Act, the Business Entity Transactions Act. And then 30 through 33 are BESTA, the Business Entity Standard Treatment Act. And so you can kind of look to the brief for more specifics on each of those. And I'll stand aside and answer questions you might have.
Okay, thank you. Committee, what questions do you have for the reviser? Any? Okay, thank you, Jason. We appreciate it. Okay, we will begin with the proponents. We have William Quick from the study committee of the Kansas Bar Association. And are you here in person? Wow, okay. That's great. It says WebEx. So, all right. Good to have you. Welcome to committee.
Well, thank you, Madam Chair. We appreciate you giving us this opportunity. My name is Bill Quick. I'm with the Polsonelli Law Firm. I'm here with my colleague, Bill Matthews, who's with the Folston-Siefkin Law Firm. We represent a study committee of the Kansas Bar Association that has reviewed the Kansas Revised Limited Liability Company Act. And we are proposing a group of omnibus revisions to update the act. We gave a fair amount of detail about the background of the act and what we were proposing a week ago to this committee. So I'm going to dispense with that portion. I know it's disappointing. There's a huge crowd here, clearly, to hear about, limited liability company law in Kansas. But, rest assured, you'll have a chance to have your questions answered. So if there are any questions, I would be happy to field those.
That has got to be a record. Thank you. Committee, you did hear a lot last week about this, but what questions have come up since then, or what questions would you like to ask Mr. Quick? Representative Vaughn.
Thank you, Madam Chair. Thank you, Mr. Quick. I'm sorry if this was talked about last week. I just wondered, is this law going to be the same as what's currently in statute in the Delaware law, or does it differ? Does it incorporate existing case law in Delaware? How are the two similar and different?
So, short version. For the past 50 years, Kansas has modeled its business entity statutes after those found in Delaware, because Delaware's, generally known as the gold standard of business entity law in the U.S. They have special courts of chancery, which are dedicated to hearing only business law cases, which is unique to them. Their legislature meets annually and makes changes and updates to their statutes to reflect things that have come down in case law, or things that are happening in the economy, or things that are happening in the business community. So what our committee does is periodically, and I believe the last time we looked at this was in 2019, we will, get together as a committee. We've got practitioners, we've got law professors, we've got people from the banking community, we've got people from the chamber that get involved, we've got the Secretary of State's office, and we come together, take a look at the changes that have been made in the Delaware statute from the last time we had one of these omnibus amendments, and see if the changes that Delaware has made should be made in Kansas, and if there's any deviations from that based on Kansas public policy. So that's what we have undertaken. As I said, the last time we did this for the Limited Liability Company Act was 2019. I believe the last time we did this for the corporate statute was 2 years ago. So we kind of alternate between the corporate statute and the LLC Act to make it manageable. Does that answer your question?
As a clarification, so you feel this mirrors the Delaware statute?
Yes.
Fairly well, okay.
Yes, and the benefit of that is, as I said, they have a court of chancery. They have a lot of litigation in Delaware over their statute. Kansas, not so much. So what the benefit is to Kansas is anytime there is a dispute, practitioners can look to see what Delaware courts have decided on that issue. And Kansas courts will often, adhere, or at least take under very strong advisement what Delaware has ruled on certain matters to inform their decision. So it makes our business entity laws efficient and user-friendly.
Thank you.
Committee, any other questions for Mr. Quick? Okay. Oh, I'm sorry. Yeah, Representative Carmichael.
Thank you, Madam Chair. First, is a procedural matter I need to inquire. I have testimony from Mr. Quick on behalf of the Kansas Bar Association. Then I have a second set of testimony that was handed to me as I went in the door that's addressed to you from the Kansas Bar Association, and it's on behalf of Mr. Matthews, who I see in the back of the room. Might I inquire, are they both testifying, or do I ask Mr. Quick questions about Mr. Matthews' memoranda? Different bill? No?
I think Mr. Matthews' testimony is about a bill that was proposed by the Kansas Chamber.
Could you go ahead and speak into the microphone? Yep.
I think Mr. Matthews' testimony has to do with a separate bill that's introduced by the Kansas Chamber having to do with series,
Okay, and that's
which
the
is a
bill that
specific
we
subset.
are apparently not hearing that bill. as
We're
I
not hearing
understand it.
that bill.
So that bill is going to come in as an amendment to this bill, presumably.
Exactly. Mhm.
Without the benefit of being able to hear Mr. Matthews' testimony on the provisions of the bill. I just want to make sure I'm tracking what we're
I'm
doing.
not sure about Mr. Matthews being here, or I don't have him listed on my
Okay.
sheet. So I'm not sure what the,
I think
testimony that you were
they
here?
submitted testimony on 2355, but that's a bill that's not going to be heard. We're just going to see an amendment that brings in 2355, so we'll probably never get to Mr. Matthews. Let me go ahead with Mr. Quick. I appreciate the explanation. Thank you.
Well, can I phone a friend? Because he is here.
Mr. Quick, I don't want to put you in the spot, but I visited with Lockton's public relations people this morning, and again with their lobbyists at lunch, and they all tell me that they are going to put this HB 2355 into the bill you're here to testify on, but they also tell me that you're their attorney and that there might be a conflict of interest, or at least the Posinelli firm.
Polsinelli does represent Lockton.
So I don't want to put you in a bad situation, but you're the only witness I've got. Can you explain to me what, if anything, is wrong with the provisions of 2355 that we know is going to be coming into this bill by way of amendment? And I know that Mr. Matthews prepared an extensive memorandum on the topic.
So,
I have
Mr. Quick,
Matthews
so
to the-
is he, Mr. Matthews is here?
Yes.
Okay, so I think we'll just let him answer that question.
Thank you. I appreciate that,
Mhm.
Madam Chair.
And
Yes, you do.
so if you will, like, give it, 2 to 3 minutes will be adequate. Thank
Absolutely.
you.
Thank you, Madam Chairman. Representative Carmichael, you had a question?
Yes, my question is, I know you've prepared a memorandum that discusses a number of things that are described as deviation from Delaware, isolated amendments, inconsistency of amendments, legislating other law through the KRLLCA. I can't testify. Can you tell me what the problems the committee found with this alternative competing proposal regarding serial LLCs?
Yeah, so, as this is draft testimony, if the bill, independently gets heard, although we understand that it might be proposed as an amendment. We see lots of issues. One, it deviates from Delaware. Secondly, I think the informational testimony that was given last week characterizes their amendments as modernizing the LLC Act. I think that's far from the truth. They're based, it looks like, entirely on provisions of the Missouri Act, which were adopted in 2014, and those provisions haven't been updated since. Of the 21 states other than Kansas and Missouri that have adopted series LLCs, only Illinois shares in common any of their proposed changes. And most importantly, all the states that have adopted series provisions in their LLC statute under a uniform act that was proposed in 2017 or 18, none of those do. So in our opinion, not only does this deviate from Delaware, which has served as the model upon which we based our entity law for the past 50 plus years, but it doesn't appear to even be where all the states are going with regard to how we treat series. I'm also worried about language about consolidated tax returns and filings. I'm worried about other language related to fraudulent transfer, all of which are laws outside of our LLC Act. If we want to discuss those and their merits, it would seem to me that those would be the proper, those would properly be held or heard in a revenue bill that proposes to amend our revenue code, or in other laws. So for those and many other reasons, we're not in favor of those provisions.
Quickly, to round this up, the second question is, Lockton's representatives described these changes or deviations to me as grammatical changes that are based upon new developments in Delaware case law. And in fact, all they're doing is codifying new developments from Delaware case law. Is that a correct interpretation of the circumstance?
Not to my knowledge. As a matter of fact, the changes that we have in our bill to the series provision 1776, 143, those are based on amendments in Delaware that were passed only last session. They closed their session in August. It incorporates those changes, and we haven't seen what they're proposing now, but that would not be to my knowledge. And by the way, that would be a remarkable coincidence given that all of their language is identical to language from the Missouri statute from 2014. So that doesn't seem to jibe to me.
Thank you,
Okay,
Madam Chair. I
thank you.
appreciate you allowing me to ask those questions.
Yep, and thank you for coming up. We appreciate that. Well, the next proponent is Clay Barker from the Kansas Secretary of State's office. Welcome, Clay.
Thank you, Madam Chair, members of the committee. My testimony will be very brief. The Secretary of State is part of the working group with the Kansas Bar Association, so we support the bill, but their expertise in the substance of LLC law exceeds ours. I'm here to only testify in one section in case members of the committee had questions, which was section 16 of the bill. The filing fee to form an LLC or for a foreign LLC to come into Kansas is set by statute at a fixed $150. There's no leeway to change that. That is different than most filing fees, which have a ceiling set by statute, but the Secretary is allowed to reduce the fee by regulation. For instance, corporations are 150, but by regulation, can reduce it to 75. And our one ask in this bill is that we be granted that regulatory authority to keep the 150 as a ceiling, but lower it down. And just in fairness to the legislature, all that money goes to state general fund. I don't know how much it would be lowered because we're doing a comprehensive review of all our fees, but there's 29,000 LLCs on average form in Kansas each year. So that's about 4.3 million. So if we reduce it, it would come down somewhat, but I can't tell you what. And before we ever reduce a fee that goes to SGF, we talk to budget and key legislators about it, about the impact. And I'll stand for any questions, Madam Chair.
Okay, thank you. Committee, what questions do you have for Mr. Barker? Okay, thank you so much. Appreciate it. Okay, are there any other proponents to this bill? Okay, we will close that portion of the hearing and we will go on to neutral. I don't believe we have any opponents. I'll first call up Eric Stafford from the Kansas Chamber. Welcome.
Thank you, Madam Chair and committee members. Good afternoon. Eric Stafford with the Kansas Chamber. Crowd this big, I feel like we should all have walk-up music for our testimony. We are here today as a neutral party. You guys heard some comments last week on the informational hearing about the changes that we are after and pursuing to the bill before us today. Before I get started, I do want to thank Mr. Quick and Mr. Matthews for their work and expertise in this area and for the bill that they've worked on. We do greatly respect their knowledge and efforts that they've put in to modernize our statutes in Kansas. After last week's hearing, we did have a good discussion with the Bar Association to understand the intent of what they're after, which we do support and appreciate, which their intent is to minimize litigation for Kansas businesses and eliminate uncertainty. So we do understand that. But we also don't believe that we're creating a climate of more uncertainty. You guys heard testimony relative to the proposed changes in Kansas series statutes and the suggestion that the Bar Association doesn't support any deviation from Delaware for LLCs or series LLCs, which Kansas has long adhered to. I'll first start by saying our original series statute was based on Illinois law, not Delaware. In our opinion, this is an issue of semantics, absolute alignment versus substantive alignment. In numerous circumstances or instances, both the case of the existing Kansas LLC statute and the proposed changes that we are asking for the series LLC statute, there is deviation in an absolute sense today already in Kansas law. There's different terminology used between Delaware and Kansas. For example, Delaware statute references and incorporates protected series, which Kansas does not have under existing law. Similarly, unlike Delaware, the Bar Association is proposing that Kansas not permit series LLCs to be formed for businesses transacting and issuing policies of insurance or assuming risks. So there are already existing deviations in place with respect to precedent. It's also important to note that the Kansas series LLC statute, as I mentioned, came more from Illinois versus Delaware. The Illinois statute, which was adopted in 2005, is a statute that is also viewed favorably and has been incorporated in whole or in part by states such as Kansas and Missouri. And I mentioned what we passed in 2012. So the legislature in these situations adopted what may be better termed certifications and refinements to the LLC statutes, which may technically and in an absolute sense deviate from Delaware, but again, substantively, we would disagree that there's much deviation. So what we are asking for the committee to support is nothing more than similar clarifications in our series LLC laws, and not necessarily such an absolute deviation from Delaware. We are here with the goal that the language that you have before you or that we presented in the informational hearing last week will make Kansas a more attractive place for investment and an easier place to operate under the series structure. We believe that these changes are adding clarity to our statutes, not deviating from them, and there are currently distinctions in place, but we deviate in what we already believe to be in the best interest of our state today anyway under existing law. So in closing, appreciate the opportunity to testify here today. Happy to answer any questions that you all have. And again, thank you, Madam Chair, for the time to appear today.
Mhm. Thank you. I think I'll go ahead and have the next neutral come up, and then we'll see what questions we might have for either one of you. So I'll call Kelly Vanswall to the podium. Welcome to committee, Kelly.
Hi, thank you, Madam Chair and members of the committee. You heard me in our informational last week speak on this. In general, the Kansas Bankers Association has been a part of these LLC and series LLC conversations from the start, and we've always had some concerns with series LLCs. We're supportive of the bar's bill to update the statutes, and we are supportive of the Delaware model. However, the chamber reached out to us on their amendment, and we agreed that if the legislature was comfortable moving away from the Delaware model, we wanted to work with them to address some of our concerns. So that's part of what you see in the language they brought, is their attempt to address some of our concerns. One of them is the tax provision. We worked with them to narrow that language. Tax is an issue for us because when a garnishment or a tax levy comes into the bank, it's done by their tax ID number. So that's how we match things. So if everyone has the same tax ID number, that becomes an issue for us. Another part was including language to clarify fraudulently moving collateral between the series. There we reference KSA 33102, which is about the transfer to delay or defraud creditors. Perhaps series are already covered under that, but we felt there was some uncertainty there, and that having it in there was needed to kind of mitigate that risk. So we appreciate the parties' efforts to work with us on some of that, and I'm happy to answer particular questions. On just the banking part, I'm not the series LLC expert.
Okay, thank you. Yeah, we'll do questions now. Committee Representative Lewis.
Yes, if I might, thank you. Thank you, Madam Chair. So am I to understand that you've talked with the chamber
Mhm.
and you, with the changes that you've discussed with them, support the chamber's amendment?
So we would be neutral on their amendment because they've addressed our concerns. Does that help?
All right, thank you.
Other questions? Representative Curtis.
Thank you, Madam Chair. So you're okay with working through those issues, but the preference would be to adhere to the Delaware model. Is that correct?
It's the cleanest approach in our understanding, however, that we still wanted to work with the other parties in case we went the other way.
Thank you.
Representative Vaughn.
Thank you, Mr. Chair. This question's for Mr. Stafford, if I can. So in your testimony, you talk about how we have a history of deviating from Delaware and, you know, that kind of justifies the deviations in this law. But from where I sit, it looks like these deviations were designed with one company in mind. So I'm trying to understand what justifies those deviations. Why is it better for Kansas? Why are they better than the Delaware model? And I'm just wondering if you might be able to speak to that.
Sorry, I'm pulling up the right testimony here. Yeah, thank you, and for your question, Representative and Madam Chair. Again, I think it's deviation in technical senses and that the language might not be identical. But if you look at the amendments, and we talked about this last Thursday, if you look at the amendments that we're adding, I think you can make the argument that they're not substantive changes, they're clarifications where you're talking about otherwise conduct business to exercise the power of a limited liability company under this article. Limited liability company of its series may elect to consolidate its operations. So it's more technical in terms of like the business operations operating under a series LLC, right? And so it's not, we're not in our view, asking for language that is substantively different. The language is different, but we already have existing language that is different compared to Delaware today. I think it is a little unfair to paint the picture that Delaware's this gold standard that we've never had any differences from in the state of Kansas. And we have. We have historically had differences because our initial bill was based on Illinois. Now in 2019, they might have revised it and moved closer to Delaware, but it doesn't mean that we've never been not tied at the hip with Delaware. So I think it's a easiest way to say it's more of a semantics thing than anything else.
I guess my counterpoint would be if it is a semantics thing and we have professionals in the field indicating the Delaware model's better, why wouldn't we go with the Delaware model?
Well, professionals don't have a uniform opinion. I think everybody has an opinion, right? And so that's the policy debate.
Thank you.
Representative Carmichael.
Thank you, Madam Chair. Mr. Stafford, you obviously heard the testimony of Mr. Matthews of the Folston firm, one of your leading members of the chamber.
Sure, yeah. Personality is as well.
Sure. And you read the testimony, no doubt, of Mr. Quick from the Pocinelli firm.
Yep.
They're describing these as not being grammatical changes. They're telling us, certainly Mr. Matthews is telling us, that these are in fact substantive changes with real impacts. You are not a lawyer. You certainly don't practice commercial law. Why should we accept your testimony over that of two of the preeminent authorities in Kansas in the field, as well as the collective wisdom of the Kansas Bar's commercial law section? Why should we accept Eric Stafford's word instead of these experts' word?
Because I'm Eric Stafford. No. Just no, I'm just kidding, Representative. I'm just kidding. No, appreciate the spirit of the question. Yeah, no, honestly, I think there's, again, I think there's differences of opinion. There are businesses that are operating in Missouri under these exact laws, and they feel like they're working well. And so we're just, in our view, trying to strengthen the opportunity for business to operate here in a way that agree to disagree with their highly respected opinion, because they are highly respected professionals, not trying to say that they're not, but I think there are differences of opinion on the amount of substantive changes that are being proposed.
Thank you, Madam Chair. I have no further questions of the Eric.
Okay, committee, I think we'll go ahead and close the hearing. I don't see any more questions. All right, thank you so much for being here. I will close the hearing on House Bill 2371, and we will go ahead and open the hearing on House Bill 2348. What you all just saw, you who are still sitting here in the room, this is what we do in the Judiciary Committee. So it's a little bit different probably than normal, and having you here is different for us too. So we're looking forward to having a lively debate. So I will call on our reviser, Jason Thompson, to give us a bill brief on House Bill 2348.
All right. Thank you again, Madam Chair. As you said, Jason Thompson, Revisor's Office. I'll try to keep this very short. House Bill 2348 is the bill about tenure at post-secondary educational institutions. It's a new section of law. I go through each subsection briefly in the bill brief. I won't necessarily do that here. Just the highlights. Subsection A is the one that says an award of tenure may confer benefits, but it's discretionary and conditional, and it does not create an entitlement, right, or property interest in a faculty member's current, ongoing, or future employment by an institution. So that's the big lead-off subsection. The next one kind of prohibits the Board of Regents and institutions from defining or awarding tenure in a way that goes against that first subsection. The next one talks about no award of tenure in existence prior to the effective date of this act can be considered, or in existence on the effective date of the act should be considered or deemed an entitlement or a property right. So it attempts to retroactively change that as well. Subsection D deals with the ability to revoke, limit, alter, or modify these rights or interests, I guess, depending on your terminology. And then finally, subsection E, or not finally, subsection E gives the, nothing in this section shall be interpreted to infringe on constitutional rights, which of course almost goes without saying, but it is mentioned there. And finally, subsection F is the definition section. So that's where you'll find, for example, one of the key terms, institution, means post-secondary educational institution as defined in another KSA, and I've given you that definition in the bill brief. It's any public university, municipal university, community college, technical college, and institute of technology. So essentially all of the things you would think of are covered as institutions under the bill. Other than that, I think I'll just stay out of the way and answer questions if you have them for me.
Okay, thank you. We'll do questions from the committee now for the reviser, Representative Lewis.
Thank you for that, Mr. Thompson. And this may be a better question for researchers and revisers, but so the bill addresses the property right in tenure. And my question is, how clear is it in case law or statutory law in Kansas that in fact a tenured professor does currently have a property right in tenure?
Madam Chair and Representative, I'll just give you the very high level overview of what we kind of came across in the background here. And you'll probably hear about a couple of these cases. There's a very recent district court case within the 10th Circuit that says it is a property right, and that's probably why we're here, and that's why you'll hear about it. There's an older case, I want to say 1998 question mark, that's referenced in that opinion as the basis for the plaintiff saying there is a property right that should be protected. So at least in some 10th Circuit precedent, we have that. But from other research, I think you'll hear from proponents and opponents, there's some disagreement about what the law is on this, but that's what I know.
Thank you.
So the case that you referenced from 1998, was that a 10th Circuit case, or that was a Kansas? I mean, where did that originate, or was that was quoted?
Sure.
Was
Thank you, Madam
referenced.
Chair. So plaintiffs cite the 10th Circuit's decision in Tonkovich v. Kansas Board of Regents in support of the property right. And that is a 10th Circuit case from 1998. And I can get the citation if anybody needs it. But yeah, it's in the current district court opinion that kind of.
Okay, thank you. Representative, we'll do more questions. Representative Barth and then Osmond.
Thank you, Madam Chair. My question is in reference to the definition of unclassified. I notice it just mentions unclassified. There's no list of classified in here. So could you describe what unclassified is, please? Thank you.
Madam Chair, unfortunately, I cannot. That is what the definition says. Faculty means any unclassified employee of any institution whose primary duties. That's from my education revisers, and so I can't give you a better answer than there's obviously a difference, and I think some of the conferees can probably tell you the difference between classified and unclassified. I mean, I know as a student I heard about classified staff, but I can't remember what the legal distinction was, so.
Representative Barth, did you have a follow-up?
Thank you. If they can clarify during testimony or something like that, that would be helpful.
Okay, we'll see if staff is able to do that during the hearing. Thank you. Okay, Representative Osmond.
Thank you, Madam Chairwoman. In my quick search of the KSA, I wasn't able to find, is there an actual definition of tenure as it's listed in the KSA right now? I kind of looked through, quickly through chapters 72 and 74, but there's no definition.
Madam Chair, short answer, no.
All right, thank you.
Representative Carmichael.
Thank you, Mr. Thompson. The Tonkovich versus University of Kansas case is, I believe, the established precedent at this point, at least in the 10th Circuit, and it arose out of a very unfortunate circumstance involving one of my law professors at KU and some of the students that I studied with. That being said, do the words of this bill purport to retroactively abolish the property right involving tenure as it has existed since Tonkovich and even before? Is there a specific retroactivity provision in the bill that you're able to discern?
Madam Chair and Representative, yeah, and I kind of just hit the high points here, but I'll point you back to subsection C of the new section. No award of tenure in existence on the effective date of this act shall be considered or deemed an entitlement right or property interest in the current, ongoing, or future employment. So to me, that's trying to say anything in existence now shall not be deemed that. That's of course countered by subsection E that says nothing is interpreted to infringe or abrogate on a constitutionally protected right. So if you've got a vested right, due process says you can't just take that away. So there's the push and the pull. You attempt to be retroactive to the extent that you can, I think is the attempt in my high-level view of this, right? Not being someone down on the ground litigating this case. But yeah, that's the push and the pull between subsection C and subsection E, and a big reason you've got such a big crowd.
I agree on all counts. Thank you, Madam Chair.
Okay, committee, are there any other questions for the revisor? Okay, Jason, thank you so much. I know there's at least one seat up here on the front row, and there might be some other ones, but I hate for you all to stand up. So there's at least one seat up there, so great. Okay, but glad to have everybody. Okay, we will go ahead and hear now from the proponents. I will call up Mr. Stephen Lovett, private citizen.
Okay, mic's on, thank you. The gentleman said earlier that maybe we should have walk-up music. I assume that mine would have been something that would have introduced Darth Vader at this point. It appears as though I'm probably the cause of your interesting afternoon. I've got a few comments to make. I've provided written testimony. I hope that I don't take any longer than 10 or 12 minutes, if you'll bear with me. My name is Stephen Lovett. I am the author of...
If it's okay, we will say 10, and I'll just go ahead and we'll go ahead and try to keep it to 10, if that's okay with you.
Yes, ma'am, of course.
Okay, that's great. Thank you.
Please don't hesitate to flag me down. I'll do my best. My name is Stephen Lovett, and I am the author of House Bill number 2348, providing that tenure at post-secondary educational institutions shall not be a property right. I have authored this bill in my personal capacity, and I appear today as a citizen and taxpayer concerned about a matter of significant public interest. For purposes of House Bill 2348, it might also be relevant to know that I am a lawyer and currently hold tenure as an associate professor at Emporia State University. The House and the Senate, in my opinion, have already undertaken bold steps to ensure fiscal stewardship and clearly have the resolve necessary for all Kansans to prosper in the long term. I share that resolve. I apologize that my one-pager bill is taking so much of your time this afternoon. If you will refer to the written testimony comments, then I'll walk through those and take a few minutes to do so, highlighting a few things. The first off, is that a property right can create an entitlement in future employment. Property rights are not created by the U.S. Constitution, nor are they created by federal law. Property rights are exclusively created by state law and state action. When a property right is created, though, courts then determine if it rises to the level of a constitutional protection. And if it does, the property right enjoys the protection of the Constitution's Due Process Clause. The Due Process Clause provides that certain substantive rights cannot be deprived except pursuant to constitutionally adequate procedures. On December the 5th, 2024, just a few weeks ago, 8 or so weeks ago, the Federal District Court for the state of Kansas entered an order with certain findings in a lawsuit in which I am an individual defendant. Along with myself or other key leaders from Emporia State University and 15 regents, current or former, of the Kansas Board of Regents. In that finding and that order the court entered, it identified 3 elements that I'd like to bring to your attention. One is that tenured university faculty are entitled to continued employment as defined by Kansas law because of longstanding K-Board policy. Therefore, tenured university faculty members possess property rights in their continued employment, and those property rights invoke the U.S. Constitution's Due Process Clause. Just so we're clear as to that concept of entitlement, the Kansas Supreme Court in 1980 in Vaughn versus Nadel identified that as a vested right, not specifically as to tenure, but just the concept of a property right. And a vested right is one that is so fixed, it is not dependent on any future act or contingency. The findings by the Federal District Court rely on K-Board policies which restrict the termination of a tenured faculty member only for cause. Unlike almost all other Kansas state employees, a tenured faculty member at a public institution can only be terminated for a limited number of reasons. While I am in favor of tenure, and this bill it does not abolish tenure, I am not in favor of it being a property right because it obligates Kansans to a long-term, unfunded fiscal liability. Why is this significant, and how significant is the liability? I'll give you an example from fiscal year 2023, there were approximately 2,834 tenured faculty members or tenure track faculty members employed by the 6 four-year educational institutions governed by KBOR. Assuming on average that each of those faculty members has a gross compensation of $91,000 per year, the annual payroll liability for this unique employment status is $206 million every year. It's long-term, so if you extrapolate out 10 years, that's $2.6 billion for the state of Kansas for this payroll liability. While other state employees, including other faculty, can be terminated at the discretion of the hiring institution to accommodate things such as budget cuts, FTE reductions, or even programmatic changes, tenured faculty cannot be terminated except for cause. And even then, they must be provided sufficient due process, which costs even more money and takes even more time. The property right of tenure, as it's currently characterized in the state of Kansas, impedes or restricts the needed change of higher education in our state. Over the past 8 years, over 100 universities have closed across the United States, and there's an estimate that another 80 will close over the next 5 years, and that's from the Federal Reserve Bank of Philadelphia's recent study. Short of restrictive for-cause events, public universities are prohibited from making discretionary adjustments to this special group of employees, regardless of budgetary restrictions or the need for programmatic changes. And at a time when higher education is under intense financial, societal, and political pressures, and at a time when universities are more competitive than ever, trying to act upon operational, budgetary, and programmatic changes that will then provide lower costs and better employment opportunities for students, sound fiscal restraint, responsiveness to economic and workforce conditions and needs, and better stewardship of physical assets, public universities are encumbered financially and culturally by the unnecessary impediment of tenure as a property right. Property right as tenure is not necessary to preserve or protect academic freedom. One of the greatest fallacies obstructing necessary change in higher education is that academic freedom is preserved and protected by tenure or due process, when in fact it is protected by the First Amendment of the United States Constitution. Advocates for academic freedom point to faculty members' need to freely discuss and teach and explore all relevant matters of concern in the classroom and all avenues of scholarship without the fear of censure or discipline. They need to be free to address matters of institutional policy or action and should be able to speak and write as citizens without fear of reprisal. I agree with that. Those arguments underscore keys to a university's free marketplace of ideas and inquiry, but they misguidedly maintain that tenure and appropriate due process are the two most essential protections of academic freedom, and that is not supported by federal law. The United States Supreme Court has held that academic freedom has long been viewed as a special concern of the First Amendment. The First Amendment, and not due process, promotes the robust exchange of ideas which delivers truth out of a multitude of tongues, rather than through any kind of authoritative selection. The constitutional rights of free speech and expression, as well as equal protection, are the actual essential protections for academic freedom, not tenure or due process. Public employees, such as faculty members, do not surrender their First Amendment rights by reason of their employment. Academic freedom means that faculty are free to engage in the professionally competent forms of inquiry and teaching that are necessary for the purposes of the university. In fact, a non-tenured faculty member enjoys as much legal protection to pursue academic freedom as a tenured faculty member. Currently, tenure in the state of Kansas provides an unnecessary shelter at great financial and operational cost to our taxpayers and our universities. It primarily results in nothing more than personal gain. House Bill 2348 eliminates the property right of tenure, but not tenure itself. I'm sure it will be no surprise that I've received a number of communications over the past 2 days. I want to share with you an excerpt from the very first email that I received from a tenured faculty member here in Kansas, and he wrote the following. I just wanted to let you know that as a faculty member, I support your drafted bill. Today's atmosphere of higher education is a different context than has ever existed. In my opinion, I feel that your drafted bill adequately addresses the need for faculty members to be able to aspire to the position of a higher status and pay grade while simultaneously addressing the fact that tenure status can't coexist with programs that are net red. You're probably receiving a lot of heat from faculty, so I thought I would share with you why I think it is a needed change. I want to share another excerpt, if I may. And this was a direct quote from an individual who was describing the character of tenure before the federal district court held otherwise in December. The quote is as follows: "Tenure does not mean that a job is guaranteed. Handcuffing a university's ability to ensure financial strength in the name of tenure is counter to its purpose." The person who said that was former Kansas Board of Regent Mark Hutton on January the 20th, 2021, in an open meeting of the Kansas Board of Regents. Although I've heard otherwise as of today, I feel as though I could be confident that HB 2348 has the full support of the Kansas Board of Regents. This bill is in alignment with the longstanding and current policy of KBOR that states the following: tenure is a privilege that must be affirmatively granted by the institution in recognition of meritorious performance. In 2022, my university, Emporia State University, where I'm currently employed, relied on that board policy and other board policy that allowed us to lay off tenured faculty. We relied on the backing of the Board of Regents, and throughout our reduction in force process, we repeatedly stated and argued that the tenure was not a property right in the state of Kansas. When the federal lawsuit I've mentioned was filed, 15 individual regents, past and present, including the current chair, Regent Carl Ice, and Vice Chair Regent John Rolfe, filed pleadings and motions in federal court stating that the plaintiffs, who were tenured faculty members, had failed to identify a state law basis for a property interest that would apply to university professors in Kansas. I feel as though I should be equally confident that all of the four-year public universities would support this bill. Any institutional opposition would be non-compliant with the board's own policy and publicly stated position and would violate statutory law, which states that the universities shall be controlled by and operated and managed under the supervision of the Board of Regents. I am proud of the fact that Kansas has a long history of doing what is right, in spite of the rhetoric or violence or fear-mongering of those whose true purpose is self-gain at the expense of others. The long-term unfunded liability created by declaring tenure to be a property right is a multi-year, multi-billion-dollar receipt that our taxpayers shouldn't have to bear. While the federal court found that board policy was insufficient, it is your sole prerogative as our legislators to declare what is and what is not a property right in our state. I've been told already that I have just committed career suicide, but I am not concerned. The First Amendment protects my right to speak on matters of public interest, just as it protects every faculty member's right to academic freedom. I don't need tenure to protect me from retaliation or undue influences. And for what it's worth, I'm going to take the opportunity in this public forum, in this space, on my own, voluntarily, to renounce and surrender the tenure that I was awarded by Emporia State University. Tenure should be a badge of meritorious work and service and not a personal right paid for by my neighbors and my fellow Kansans. Thank you, Madam Chair and committee members, for your time and your continued willingness to do the right thing. I stand for questions.
Thank you, Mr. Levitt. We have a written-only proponent testimony, so we will go ahead and take questions now for Mr. Levitt, the proponent. Yep. So we'll do one question and one follow-up is what the plan would be.
Let me see if I can't accommodate that rule. One question and one follow-up on this important issue.
Mm-hmm.
Well, the first question obviously is, now that you've renounced your tenure, will you also renounce and resign your position as legal counsel at Emporia State University as well?
Thank you, Representative Carmichael, for the question. I do not feel that those are in conflict. I provide the best legal advice I can to my client. I am not here as a legal representative for Emporia State University. Emporia State University hasn't encouraged or instructed me to write this bill and had no knowledge of it before I submitted it.
Madam Chair, I don't think we had an answer. It's a simple question. Will he resign or not?
No, sir, I will not.
Thank you.
That's what I'm
My
asking.
second question, Madam Chair, is do you concede and agree that the established precedent in Kansas pursuant to the Tonkovich decision cited earlier, as well as the decision of the Federal District Court, in a case in which you are a defendant on the losing side of the lawsuit at the district court, that the law is that tenure is a vested property right?
No, sir. The first part, I do not believe that Tonkovich created that precedent. The single sentence in Tonkovich was that they assumed that tenure was a property right for that professor. It was in dicta. It did not provide any analysis or substantive law to support its opinion, and that was not a holding in that case or a finding, so it does not need to be relied upon for precedent.
Obviously, Madam Chair, I disagree with the conferee. Thank you. I've had my 2 questions.
Are there any other questions for the proponent? Representative Barrett.
Thank you, Madam Chair, and thank you for coming to committee. I guess my question would be, and I know each state can be different, but how does Kansas compare to other states when it comes to tenure as a property right?
I think that's a very good question. I can't tell you that I've done that research as to how we compare with other states, but my guess is that other states generally see it as a property right. I don't know the count on that. I think that's a presumption, a long-held presumption, but again, those are just my opinions, and I can't provide you with numbers. Yes, sir.
Does our research have any knowledge of that? Do you have any idea, Jordan?
Thank you, Madam Chair. Jordan Milholland, Legislative Research. This is not a topic that staff, at least at this table, has previously researched, but we could look into it.
All right, thank you so much. I didn't mean to put you on the spot, but I saw y'all talking, so I thought maybe you had some idea. Okay. All right, Representative Osmond.
Thank you, Madam Chairwoman. For the purposes of this question, I want to throw away the issue of property rights, and I realize that that's fundamental to the legislation at hand here, but I'm trying to understand, so tenure itself should be about the guarantee of future employment, and when we deal with this legislation and we take that guarantee away, what is left of tenure? Help me to understand what tenure is, if not for the guarantee of future employment.
I appreciate the question. Thank you. And I think that the presumption of the question, the pretext for the question might be the fallacy. That it's not intended to be or shouldn't, or doesn't have to be intended to be permanent or guaranteed employment. What it can assign to an individual is preferences. It can assign processes that are not taken of advantage by other groups of employees. It could be that if a university goes through a retrenchment process, that those who are tenured are the first in line. If there's some kind of meritorious award of pay, it could be that those with tenure are the first in line. It could be that in purposes of shared governance, that those who are tenured are the first ones in line, or those are the ones that participate in faculty senates, et cetera. I think it would be up to each institution and or the Board of Regents to identify what is meant by it being a meritorious designation based upon meritorious work, but not as a guarantee of future employment.
Okay, thank you very much.
Representative Lewis.
Thank you, Madam Chair. Are you aware of any other profession, either in Kansas or outside of Kansas, that is deemed to have a property right in their job?
I am not personally aware of that. Certainly that exists as a matter of employment contracts. That's not a property right, it's a contractual right. There's parity between the two. There probably are, I cannot think of any.
Thank you. I'm not.
Okay, committee, do we have any other questions? Okay, thank you so much. We appreciate you being here.
Thank you, Madam Chair, I appreciate it.
Yep. Okay, we will now hear from the opponents. By my count, we have 10 opponents. And I will ask you to limit your testimony to 2 minutes. Because just time for proponent versus opponent, opponents are definitely getting more time. So, but we'll try to limit it to 2 minutes, and I give a little grace, but let's try to keep it at that. From what I understand, the Chancellor's testimony and President Linton's testimony were submitted together. Is that correct? Okay, so I didn't have to decide who was going to go first because that was really hard. I was thinking back to last Saturday, thinking, who deserves to go first? But okay. Okay. So whoever, please come on up and introduce yourself, whichever one you all decided. So thank you. Welcome to committee.
Thank you, Madam Chair and committee members. I appreciate the opportunity to be here. Doug Gerard, Chancellor at the University of Kansas, and I'm here in opposition to House Bill 2348. I don't believe I'm breaking the law because I am here with the full knowledge of my board. To summarize what probably would have been 10 minutes, in 2 minutes, I will try to do that. But most importantly, I want to say that tenure has been a foundation of research universities since the early 1900s. It is the foundation in which our research universities in this country are built and, quite frankly, are the envy of the world, which is why people come here to study. It is also what's enabled us to become the biggest economic engine and research enterprise in the world. And it is instrumental to what we do. And tenure status is not granted, it's earned only after a lengthy assessment process and evaluation. And once tenure is earned here in Kansas, it's also followed up with a post-tenure review every 7 years. And that's a detailed assessment of the faculty members' accomplishments and areas of performance that need to be addressed. And it's also, and if the opportunity, I would just say quickly that tenure was eliminated or significantly weakened, that would have a devastating impact on our institution's ability to recruit and retain the best scholars in the country. To think just very briefly on the economic impact this has, our research faculty, our faculty as a whole, through their education and their research, or just for KU alone, and I'll let President Linton speak to K-State, our annual economic impact in the state of Kansas is $8 billion. And that is the largest economic impact of all but one company in the state of Kansas. In fact, if KU were an economic sector, we would be the 9th largest economic sector in the state of Kansas. And really that's driven very much by our research enterprise, which is conducted by our research faculty and our tenure track faculty who bring in almost $550 million a year of research dollars to the state of Kansas and have over 4,000 jobs to do that. And to put that in perspective, that's more jobs than the Panasonic company will be bringing to Kansas when they open their new plant. And we also create new companies. We've created over 50 companies, over 750 jobs at the KU Innovation Park, and we continue to create new ones. We also help the state do things like recruit Panasonic to the state of Kansas or drive the Tech Hub initiative or the Hydrogen Hub initiative. That happens through our faculty and their expertise. We, of course, partner to make sure that we have a workforce for the future for Kansas, partnering with industry. We create over 7,200 degrees and certificates. Over 70% of our Kansas graduates stay here, and over 35% of our out-of-state graduates stay here as well. There's not another entity in the state that can make that claim. But should we lose our ability to do meaningful tenure, we will lose our best faculty and we will not be able to replace them. They will just go places where they have that protection. So with that, Madam Chair, trying to keep it to 2 minutes, I'll pass the baton to President Linton at K-State if that's all right.
Okay, that's great. You did pretty good. So yeah. Thank you for your testimony.
Is that a B or a C?
Yeah. No, I'm not saying, but so we'll wait and do questions at the end of the opponents committee. So, okay, thank you. Welcome to committee, President.
Thank you, and good afternoon, Madam Chair and rest of the committee. I support my colleague in opposition of this bill. My goal today is to talk about the impact of tenure for faculty at Kansas State University. As a land-grant university, Kansas State University powers economic growth across the state of Kansas through research, teaching, and service. Our work generates $2.3 billion in yearly economic benefits just to the state of Kansas, with research breakthroughs in critical fields like agriculture, food and animal biosecurity leading the way. The success of this research relies on tenured professors who have dedicated their careers to solving Kansas challenges. Eliminating tenure would hit hardest in the areas where K-State leads the nation. Our cutting-edge work in animal health and food safety, our advances in agriculture technology, our vital work in protecting the nation's food supply through biosecurity research, and our innovations in engineering. Without the stability that tenure provides, we'd struggle to keep doing this essential work that gives Kansas its competitive edge. It would be very difficult to retain our strong faculty and near impossible to recruit new ones. None of our peer institutions offer faculty positions without the protection of tenure. We would no longer be competitive in retention and recruitment of new faculty. Kansas State University is a strong R1 research institution, and tenure helps to support our success. Tenured faculty at K-State contribute $218 million in annual research expenditures. They hold 172 active intellectual property licenses and have helped create 14 active startup companies based on K-State technologies. K-State tenured faculty also attract over 300 industry-sponsored research grants each year. These efforts have resulted in the creation of 228 family-sustaining jobs, the retention of 364 direct jobs, and $888 million in new direct capital investment. Furthermore, Kansas State faculty have played a key role in expanding 285 existing businesses, attracting 1 new business, and supporting the formation of 44 new businesses. Thank you for listening. I hope I did okay in my 2 minutes.
You did a little better than your colleague, but.
That's all we want to hear is
Yeah.
a little bit better than KU.
Okay, thank you so much. We'll now have Ron Barrett Gonzalez, State of Kansas Conference of the American Association of University Professors. Welcome to committee.
Thank you, Madam Chairwoman. I appreciate it. So my name is Ron Barrett Gonzalez. I'm the Committee A co-chair for the American Association of University Professors. My other co-chair, Rob Cadlett, is right there from Emporia State. The bill as proposed is specifically introduced not to advance some noble cause or item of great interest to the taxpayer, but to address directly a case that's currently being litigated before the U.S. District Court of Kansas. HB 2348 is specifically structured to address property rights, as you've heard, and rights of faculty members, which courts have consistently ruled are covered by the 5th and 14th Amendments of the Constitution and due process rights granted therein. Judge Julie Robinson of the U.S. District Court for the District of Kansas mentions property rights and interests of faculty members no less than 24 times in her 5 December 2024 ruling. The KSAUP believes that it would be inappropriate for the legislature to attempt to interfere with a case before the court, especially as the case is being actively heard and has not made it through the entire appeal process. The principal author of the bill, HB 2348, Stephen Lovett, has a personal stake in the bill as he is a named defendant in the litigation, giving him a gross conflict of interest. If the bill, if passed, would effectively take property rights, as we just heard, from thousands of faculty members from more than 30 institutions across the state without due compensation or due process. The stripping of rights will be that faculty members across the state will have no tenure-related due process protections, which will in turn will very adversely affect national rankings, as you just heard, and accreditation at post-secondary institutions. Schools of law are accredited by the American Bar Association. They stand to become unaccredited if tenure is threatened, the very definition of tenure is threatened, but demanded by the ABA. Schools of engineering, which rely upon accreditation by the Accreditation Board for Engineering and Technology, also stand to become unaccredited, as the very definition of tenure under HB 2348 is incompatible with accepted ABED norms. Aside from a loss of accreditation, national reputations will be catastrophically harmed, as we just heard, and it will become almost impossible to recruit quality faculty members. The loss of quality faculty members means that the people of the state will have to send their children out of state to receive a quality education and thereby be employable in today's highly competitive job markets. Medical schools like the KU Medical Center, from which my chancellor is a member, not only stand to lose accreditation and quality faculty, but this would imperil National Cancer Center designations, thereby threatening the very lives of people. So in short, the bill could bring about very serious and lasting harm to the people of the state of Kansas, all to advance a short-sighted attempt to meddle in an issue which is squarely before the courts.
Thank you. Thank you. Okay, I will call up Dr. Kim Morse, WU Chapter, American Association of University Professors. Welcome to the Judiciary Committee.
I would prefer, yeah. Clearly, those things and I don't get along very well. First things first, I would like to acknowledge some people who are here. If you are a student, please stand. If you are faculty, please stand. Thank you for who you are and all you do. We are in good company every day. Thank you. So, it is my honor to serve as the president of the Washburn University chapter of AAUP. I am here on behalf of Washburn AAUP in opposition to 2348. Section 1A of 2348 states that tenure shall be discretionary and conditional. We agree. According to the faculty handbook of Washburn University, the university president may terminate the services of a member of the faculty at any time, as noted, for cause. Cause for termination consists of demonstrated incompetence or dishonesty in teaching or research, substantial and manifest neglect of duty, personal conduct which substantially impairs the individual's fulfillment of his or her university responsibilities, engaging in or substantially contributing to the actions materially disruptive to the effective operations of the university, substantial falsification of credentials, or violation of other faculty, staff, or student civil rights. In other words, existing university governing documentation defines tenure to be discretionary and conditional. Given the binding documentation already in place, we understand 2348 to be unnecessary. Furthermore, we fear that 2348 could threaten high-quality higher education in Kansas by undermining the obligations explicit in tenure. Tenure is a privilege that obligates faculty to continuous and assessed excellence in teaching, research, and service. When we earn tenure and maintain the associated obligations, we honor our commitment to educational excellence for Kansas students. According to our handbook, tenure is central to the means by which the quality of faculty is maintained and improved for the good of Kansas students. Without tenure, we lose that most essential tool that ensures high-quality education for the good of Kansas students. We untether faculty from the obligation to excellence explicit in tenure. We don't enjoy unlimited rights. We know it to be conditional. We know we have obligations when we earn tenure. We know we serve students when we earn tenure, and we know with tenure, Kansas attracts the best. We know with tenure, Kansas attracts the best. Thank you, and help us to continue to serve Kansas.
Thank you, Doctor. Now we have David Smith from United Academies of KU. Welcome to committee.
Thank you.
You can put that up on the podium, yeah.
So, good afternoon, Madam Chair, members of the committee, and so many of my colleagues and friends. I'm David Smith from the United Academics of the University of Kansas, which is our newly formed union, and I'm here to speak in opposition to HB 2348. Let me say to start with that it's a privilege to be here. As a faculty member at KU since 1990, I have been concerned with the issues that 2348 poses for many years. Issues that are, in the most basic sense, job security and employment related for thousands of state of Kansas employees and hundreds of the University of Kansas. Improvements in those areas are always possible, and we in United Academics are now working in good faith dialogue with the University of Kansas administration to make those improvements. That dialogue is going well and holds great promise, but 2348 would pull the carpet out from that dialogue in midstream, gravely undermining faculty confidence and job security. There is no need for exceptional legislative intervention at this moment. Every issue that 2348 raises is part of the oversight responsibility for higher education that the state has long assigned to the Kansas Board of Regents. That responsibility should not be undermined by an ill-considered legislative enactment which would give academics everywhere second thoughts about working in Kansas. Over the course of my career, I've been lucky enough to work with many younger colleagues, many of whom I helped to recruit. And through my involvement in United Academics, I have come to know many more. I can say from a certain personal experience that KU has an incredible roster of dedicated academics whose commitment to educational excellence is unrivaled. Let us continue to pursue that excellence, to recruit others with the same mission, to ensure that our students get top quality education, to ensure that Kansas has the best educated workforce. That, in a nutshell, is what HB 2348 would undermine, and we are strongly in opposition, and we believe that in the interests of maintaining excellence in education in Kansas, that we and the House Judiciary Committee have the same interest. So thank you.
Thank you for being in committee. We now have George Burdick, President of the Washburn Student Government Association. Welcome to committee.
Thank you. Twist that up, I'm a little tall. All right. Hello, everybody. Hello, representatives. Thank you for the opportunity to provide testimony today. My name is George Burdick, and I serve as President of Washburn Student Government Association. Washburn Student Government Association stands in strong opposition to HB 2348. As you know, this legislation would prevent post-secondary educational institutions in our state from awarding tenure as it currently stands to our faculty. Tenure exists as a foundational component to our American education system, establishing freedom of speech in areas where it most often comes under attack. This foundation is further entrenched in by our state's long-standing tradition of home rule when it comes to educational institutions, a tradition of our governance that this legislation cuts against. Further, this legislation endangers large parts of my constituency's college experience and academic preparedness. Students inevitably rely on skilled professors to educate and assist them through college. If universities in our state are unable to provide tenure or tenure-track positions to new faculty, their recruitment and retention efforts will be severely undermined. Professors who are looking for work will pass over Kansas, and professors who are already here will look for work elsewhere. This will degrade the quality of education in the state and harm our recruitment. At my institution, we take pride and rely on our skilled faculty as a point of recruitment. Our students expect and attend Washburn based in large part off of the quality of instruction provided. Should our educational acumen decline, our enrollment will follow suit. This will decrease our resources, growth, and outcomes for my constituency, the students. In addition, this will cause pain for our state's economy. The Bureau of Labor Statistics estimates that our state will create an additional 54,000 jobs that require a degree from a post-secondary institution over the next 10 years. And at current levels, Kansas will need to produce 34,000 more degrees to meet this demand, according to the University of Kansas's Institute for Policy and Social Research. Removing tenure will worsen this problem, and it will not be offset by importing new students from other states. The Bureau of Labor Statistics estimates that 179,000 workers will exit our state entirely over the next 10 years, with 113,000 of those workers holding bachelor degrees or higher. Simply put, these workers will need to be produced in our state, and the endangering of tenure will certainly hurt our economy and our society in face of these facts. Ultimately, though, while I can speak as a Kansan and as a student of Washburn, I can't speak for all the other post-secondary institutions in our state. So I called each of the other student body presidents of our state. Every single student body president represented at the Kansas Board of Regents is in opposition to HB 2348. And I think I'm out of time, so I will end it there. Thank you.
Thank you for being with us. We appreciate it. We even have a student at Washburn on this committee. I'm just not giving any hints away, but it's true. Okay. I now will call Timothy Graham, KNEA Director of Government Relations. Welcome to committee.
Madam Chair, members of the committee. As you heard, my name is Timothy Graham. I work for the Kansas National Education Association. And you may be asking yourself, what the heck am I doing here? Well, if you'll read my testimony, you'll find out that we have several hundred members that are actually higher ed instructors and professors that we represent. So you can imagine that when this bill dropped late last week and we found out there was going to be a hasty hearing on it, that we had a lot of interest of our members wanting to know what the heck is going on. So if you will look at my testimony, you'll see that we actually have a resolution that deals with tenure. And if you also read my testimony, you'll find out how we come about those policy positions. I won't repeat all that now. I will repeat what our resolution states. The resolution states, KNEA further believes that tenure, as determined by the courts, is a property right that, under the 14th Amendment, cannot be alienated from a teacher except by academic due process appropriate to the institution and for just cause. So we have a very strong stand on this, and it's very important to our members. There's nothing that I can really say that is going to be more compelling than what has already been said here today by these esteemed folks up here. What I will tell you, again, is that we have members that are very concerned about this. You know, we live in a very divided time, and a lot of the toughest conversations that we have and that people have are on university campuses. Tenure does play a vital role in preserving academic freedom, and those conversations have to be done in the classrooms. And these professors, these instructors have to know that they are free to teach and to offer courses and to have discussions in their classrooms that may not be popular outside of that classroom. We've seen it happen all the time. We legislate up here by anecdote all the time. We see people basically losing their mind about something that someone said in a college classroom. And then we have situations like are going on here today where we face a stripping of rights because of one or two bad situations. Now, you've heard from others that this, am I getting close to being done? Good. I like it when I hear that because I can leave. You've heard that this has to do with another court case. We're not weighing in on that at the moment, but we do want you to understand that we have higher ed members that are concerned about this, and we would ask you to oppose this bill. Thank you, Madam Chair.
Thank you for being in committee. We now have Dr. Hans Dalton, KU Assistant Professor on WebEx. Is he with us, Cole? Okay,
Hi.
Dr. Dalton, are you there?
Yes, I'm here.
Okay, thank you. You have about 2 minutes, so we'd love to hear from you.
All right. Hi, my name is Hans Dalton, and I'm an assistant professor in the Department of Molecular Biosciences at the University of Kansas.
Okay, I'm sorry. I just have one question. Do you have your video on, or are you intentionally no video? Just making sure that there's not a technical issue.
Hi there, I'm here.
Okay, there you are. Okay, thank you.
So I'm in the Department of Molecular Biosciences at the University of Kansas, and I started recently, so I'm familiar with the job search and what it means to look for a job and have tenure. My lab researches new drugs for rare diseases, and while these are individually rare, they affect millions of Americans out there. But unfortunately, there's not a lot of incentives from pharmaceutical companies to fund this type of research, as the financial incentives are too low. But since rare diseases affect over 10% of Americans, you likely know someone who suffers from one. So there's a great need for new drugs and treatments for these patients. So who will pursue it? Research into rare disease and more thrives in state-funded institutions, but not in industry. But there are few incentives to entering academia in the biological sciences. After receiving a PhD and spending years making middling wages despite being highly educated, the option to move into pharma or biotech is tempting. My colleague left to biotech years before I started as a professor, and he instantly had a better salary, working hours, stock options, and benefits. And meanwhile, 2 years later, I still have less as a professor. So why did I make this choice? There's two things that academia brings to the table: independence and job security by way of tenure. Independence allows me to study what I want, but tenure, is what actually reduces anxiety. It's what puts it leads to stability needed to start a family. Only the tenure process highly distinguishes academia from biotech. Tenure incentivizes scientists to come to academia to perform important research. All Kansas universities will suffer from this bill, including those needing certain definitions of tenure for their accreditation. And frankly, this is a wild time to support such a bill, as the University of Kansas in particular has seen 2 years of their highest undergraduate class sizes ever. Yet there's little funding for new faculty, and so tenure is one of the only things that incentivizes those to come to these universities, especially in the biological sciences. So thank you for taking the time to listen. Please allow the tenure process, that little incentive that exists for academic research, to continue. I want to continue doing the research in rare disease to better the lives of Kansan people and beyond.
Perfect. Thank you. Your timing was great. Okay, we now will have Dr. Emily Beck, KU Assistant Professor, also on WebEx. Dr. Beck, are you with us?
I'm here. Can you hear me?
We can hear you, and now we can see you. There you are.
Great.
Welcome to committee.
Thank you. And thank you for the opportunity to voice my concerns. I'm here testifying on Bill HB 2348 to address its impacts on academic institutions here in Kansas. So my name is Emily Beck. I'm also a new assistant professor at the University of Kansas. And while I'm new to the University of Kansas, I'm not new to Kansas. Both sides of my family are from the state of Kansas. My mother is from Greeley, Kansas, and my father is from Overland Park, Kansas. My parents, aunts, uncles, and cousins are all graduates from Kansas public education institutions. They would want me to clarify Kansas State University, but many in my family are educators in the state. And I was incredibly proud to join them when I accepted my position here at KU. My laboratory focuses on studying a large group of diseases called mitochondrial diseases. So these are diseases where the mitochondria do not function properly in cells. And what amazes me about mitochondrial diseases is that a disruption to one organelle can have such a varied impact on our health. And you probably know someone with one of these diseases. It includes Parkinson's disease, ALS, MS, muscular dystrophy, cancer, diabetes, Alzheimer's disease. My lab specifically focuses on how small genetic differences between individuals impact symptom onset and progression and effectiveness of treatment. We study foundational mechanisms impacting these groups. And studying these types of fundamental questions are not readily marketable and therefore are not strongly incentivized in industry, but they're essential questions in creating effective therapies. Academic research supports answering these essential questions by providing independence from financial incentives while providing job security via tenure once a researcher has gone through rigorous evaluation of their abilities. Removal of tenure will negatively impact all Kansas higher ed institutions and lead to a large exodus of faculty who need stability. Removal of tenure will also reduce the amount of money brought to the state to support education. I'm excited and proud to be an educator in Kansas, and I hope to be able to continue my research program here. So I really encourage, please reject Bill HB 2348. Thank you.
Thank you, Doctor, for being with us. We appreciate that. I'll now call Blake Flanders, Kansas Board of Regents. I do have a question. Are you representing the board as a representative of the board or as in just yourself?
So I am representing the board. Hi, Blake Flanders, President and CEO. I represent the board 24/7 really and never get to go out on my own. So, but I'd say good afternoon, members of the committee. Thank you for the opportunity to appear. And I'll keep my testimony really short. We have some headwinds when it comes to recruiting and retaining faculty. And the board's opposed to this based on a couple of principles. Number one, recruitment. So you may not know the last 5 years. Inflation has hit us for about 23% if you look at CPI. The pay plans for state employees have increased 15% for state employees, which has been very positive, okay? Not kept up with inflation, but very positive, except for university employees and Board of Regents employees. And those employees were shorted 5%. That's why that's the number one ask for the Board of Regents, because we value those employees. Other states we feel like would celebrate this type of legislation. Now, we're not against solutions to stop liability, but other states are recruiting our very best faculty. And we don't just lose the employment of one person. They take their entire lab with them, the millions of dollars of grants, and they go out of state. I heard a couple of things. I'm not an attorney, but I heard all kinds of legalese. This is an interesting committee, by the way. But it was like, well, I haven't done that research. Well, I need more time. Well, that's up to the board. I will tell you, I received this legislation Thursday evening. We're talking about a substantial change. I'm a little surprised because we do have a very robust process where individuals bring non-budgetary legislation to the board. We have a robust discussion about should we bring this forward. We talk about it as a board, and all the board wants is engagement. They want to partner with you to help solve these issues. Right now, we received the legislation Thursday late night, and we're here presenting testimony. So improvements are needed in the current structure. I want to say the board wants to be engaged and looks forward to working with you.
Sorry, I got distracted for just a second. Thank you. Appreciate you being here. Okay, committee, we will now do questions. I'm going to limit us to one question. But if we have time, I will come back. I mean, I know we're going to be a little bit late tonight, but if it's a burning question, you know, I like to give grace. So we'll start with Representative Curtis.
Thank you, Madam Chair. And my question would be for Mr. Flanders. Could you just talk a little bit about how difficult it is for somebody to achieve tenure status?
So I would defer to the Chancellor and President Linton, who work directly with those faculty and would better, I know what the broad process is, but I'd defer to them.
Sure, and it's probably slightly different at each institution, but it's a very stringent peer review process.
Could you go ahead and introduce yourself?
I'm sorry,
just for
Doug
the-
Gerard,
yeah.
Chancellor at KU. I apologize, Madam Chair. And I'll try and keep it to 2 minutes. But there's a robust process that
I did not do
okay. So when a faculty member joins, they also go on a plan that will get them to tenure. They do a mid-cycle review, meaning a few years into their tenure at the university. They're reviewed by their department with a plan to help them reach their goals that would enable them to get tenure. Then at somewhere between 5 and 7 years, they go through an extensive evaluation of whether they've achieved those goals. The department recommends either going forward or not for tenure. That goes to the dean, who then does a process, reviews that, and sends it to the provost, who also undergoes an extensive review of that and ultimately makes a recommendation to me. As I said earlier, there's also then a post-tenure process that starts right there that follows up with another 7-year evaluation. I actually personally am going through the post-tenure review process for the second time. And hopefully they find favorably for me. But that process continues on then throughout their career.
Madam Chair, Richard Linton, President of Kansas State University. Yeah, I know, you pushed that off. We have a very similar process at Kansas State University, except that we have 3 missions: research, teaching, and extension/engagement. Every faculty member has a certain percentage of 1, 2, or 3 of those missions. Goals are set out, expectations are met, and going through the tenure process, votes are made by the department. If it's a positive vote, that goes forward to the dean and the college. If that goes forward, it goes onward to the provost, and then ultimately full approval by the president. So it's a fairly rigorous process with pretty high expectations specifically to the job function that you were hired for.
Okay. Thank you so much. Representative Bohai.
Thank you, Madam Chair. It can probably go to the 2 gentlemen that were just there. I'm so sorry. So I understand there's a review process every 7 years and ish. Is it possible to lose tenure?
Yes, it is actually possible to lose it. Obviously, you heard actually a list of all the for cause issues. I think left out of there was probably a conviction by felony is one of those as well. So certainly they're the for cause ones, but then the post-tenure review process can actually also lead into the loss of tenure just through the post-tenure review process. That actually has happened, or people have moved out of tenure or gone into retirement, a phased retirement as a part of that process. But any one of those elements can ultimately. So this is not truly a job for, it's a job for life if you do your job and you do it well.
Thank you. Representative Schreiber.
Thank you, Madam Chair. This might be for a couple of the conferees. The question is, what's left of tenure if the property right is terminated? There's a definition in here of tenure which seems to indicate, it says it's a feature of employment and then goes on to meritorious performance evaluation and so forth. And I don't know if Mr. Levitt would like to address it or Chancellor or President Lynn or Mr. Flanders.
I'm not a lawyer either, and I'm standing in front of Judiciary. I would argue that it probably is the relevant part of tenure. Certainly, there's a meritorious and a declaration of success in your career. But what you heard a lot from our researchers was also the stability of knowing year to year. I mean, those people launch on 5 and 10-year research projects. You need to know you're going to be around to actually do that work as long as you're doing it well. And so I would argue that it actually is the functional core of tenure.
Okay, other questions? Representative Carmichael.
Thank you, Madam Chair. A difficult question for Mr. Flanders. Do we have a handle on how many Regents employees system-wide are tenured and how many are in tenure track assignments?
Yes, we could get that information. I will tell you that that has become a reduced number, or a reduced percentage over time. There's many non-tenured track, but we can certainly pull.
Understanding that we're probably going to vote on this Thursday or Friday, so getting it later is not going to work. Can you give me a ballpark estimate? Is it 10% of faculty, 1,000 or 100% of faculty? Help me.
I'm not prepared to do that, but I will get you the information by tomorrow.
So I think that was in, I mean, not as a percentage, but as a raw number in the proponent's testimony in fiscal year 23, there were approximately 2,834 tenured or tenure track faculty.
Thank you, Madam Chair. I hadn't had a chance to read all the testimony. I appreciate that. That answers my question sufficiently for now.
I could do that.
Thank you. I'll have another question if we take a second round of questions.
Are there any other questions? Representative Osman.
Thank you, Madam Chairwoman. My question is actually along those lines. I might ask, I suppose, Mr. Barrett Gonzalez might be might be best option for this question. So under the, I've lost it, I apologize. Under the proponent's testimony, he does mention, so there's approximately 2,800, I'm paraphrasing here, 2,800 tenured track employees at about $91,000, $92,000 per year, annual payroll liability of about $2 million. Over a 10-year period, the liability would be $2.6 billion. So let us assume, for the purposes of this question, that all of that information is accurate. And I guess incumbent on that is there is obviously this property right that we're discussing as to you cannot fire someone and therefore there is a liability on it. From an economics perspective, that's the liability. But I guess the question that I have is this: how much of a liability is this? Is there, what percentage would you estimate of tenure or tenure track employees are not contributing to the universities themselves? In other words, they are on paper a liability in that they can't be fired. They're just taking up space and taking up money as opposed to actively contributing to their universities.
I can certainly answer that. So I'm in a school of 120, 130 some faculty members. Most are tenure track, some are not. And I can say with confidence that the percentage of my colleagues who are not contributing is zero. We are, by our own nature, workaholics. You'll find us 60, 70 hours a week, morning, noon, and night, like K through 12 teachers. We are teachers at the core. We are scholars as well, and we do a lot of work. So we do not maintain dead wood, and the idea that we would have dead wood among us is abhorrent to us. We don't tolerate it among our colleagues, so it's zero.
Thank you. Committee, any other questions? I do have one question for Mr. Flanders. My question has to do with, I just about tenure. It's something I'm not sure about. If there was a university that did away with the program that they had, for instance, but there was a tenured professor in that program, what do you do? And because I don't know what for cause is. I mean, if we had to shrink or change around departments and whatnot. What do you do in that? I mean, what's the tenure situation in that?
Yeah, so we've had policy before where during COVID, where we had board policy where if you wanted to have a reduction in staff or reduce a program, you could do that. We also have policy around financial exigency. So if the university is has financial straits and needs to begin a reduction of force, then they can move to those tenured faculty lines. But I do think I'm not here to say it's not difficult to remove tenured faculty members, because that's why so many want to achieve tenure. What I am saying is it is difficult to achieve tenure. There's not near as many tenured lines as there was, and administrators and faculty that are concerned do have a way to exit people from tenure based on post-tenure review.
Okay, that's helpful. Thank you. Okay, committee. I will have you note that there are, oh, I'm sorry. A second question? Go ahead.
It's most courteous of you, Madam Chair. Let me take another try with Mr. Flanders. I had two questions in mind, and I should have asked you the second one first, and we'd be done by now. Mr. Lovett, in his presentation, I think said that the terminations of virtually whole departments at Emporia State University were all done pursuant to the Board of Regents policy, and that this was a Board of Regents, and inquiries were made if you're here for the Board of Regents or you're here for you. It seems on its face that it's kind of contradictory. I hear Mr. Lovett saying you all approved firing all these tenured faculty members, and yet you're here on behalf of the board saying we support tenure and we support the property right attendant there too. Can you reconcile this for me and help me understand?
So we govern 6 state universities. And so and they're not monolithic. So right now, we have record enrollments at the University of Kansas, the largest enrollments that have ever been. At Emporia State University, we had some financial issues. We'd had declining enrollments, and the Board of Regents did have a policy that said you're able to reduce programs and reduce staff as a part of that. So I don't see any conflict. But do we want to throw the tenure baby out with the bathwater and not be able to recruit, particularly at our research universities, high-end research faculty, not only recruitment, but do we also want to have those leave and take their grants? I think the answer is no. So I don't see a conflict there between the management, the fiscal management at one university versus another university saying, please don't remove this because we won't be able to recruit any high-end research faculty.
That's helpful, Mr. Flanders. Thank you. I wish Wichita State, the urban research university in Kansas, had favored us with testimony today. Thank you.
Okay, thank you. Okay, committee, I will have you make sure you look at the written opponent testimony. There's, I think we had a number, 23 pieces of opponent written testimony. Please take a look at those. And with that, I will close the hearing on House Bill 2348. Thank you, everyone, for being here. You all are welcome to stay for some more judiciary work if you'd like to. Sorry, what'd you say? What do you want to start with? 2212. Let's do an easy one. You have an amendment for that? Okay. Okay. Yeah. Okay, we're going to go ahead and do our work. If you all would kind of quietly move out, that would be great, so we can hear. We have 3 bills that we're going to go ahead and work today, committee. Should we all gavel on count of 3? 1, 2, 3. Okay, thank you all for quietly moving out. We appreciate that. Okay, committee, we are going to have, we're going to work 3 bills today. The one that was listed as possible action. Okay, I know we're a gavel. Thank you. Okay. It's not mine, but it works. Okay. So committee, there were 4 bills that we might possibly work. The one that we're not ready to work yet, I think there's still some amendments and things, is House Bill 2134, which was the Open Records Act. We are going to go ahead and do the other 3 that were listed for today. We're going to begin with House Bill 2212. And Jason, if you could give us a reminder what 2212 is. Could you, Megan, would you shut that door? Or thank you.
All right.
Okay, Jason, go ahead, please.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. This is the act about the Secretary of Corrections being able to pay amounts up to $750 that otherwise have to go to the Special Claims Committee, claims against the state.
Okay, committee, do we have any discussion on that bill or amendments on that bill? Any questions or any comments on that one? Okay, seeing no discussion, I'll call on Representative Williams for a motion.
Thank you, Madam Chair. I move House Bill 2212 favorably for passage.
Do we have a second on that one? Representative Lewis seconds. Any other discussion, committee? Okay, Representative, would you like to close on your amendment?
I close.
Committee, you've heard the motion to pass House Bill 2212 favorably for passage. All those in favor say aye. Opposed, no. The ayes have it. That one will be passed favorably.
Madam Chair, I ask that my affirmative vote be recorded in the minutes of this meeting, please.
Absolutely. Does
Thank
anyone
you.
else would like their vote recorded on 2212? Okay, thank you very much. Did you say yes? Oh, I thought I saw your hand. Okay, great, committee, thank you. We will now go ahead and look at House Bill 2173. That is a bill about the Offender Registration Act. So what discussion do we have on that one? Do we have any? Representative Barth.
Thank you, Madam Chair. All right, so we just got this amendment today, so just bear with me real quick here.
Is it okay if we go ahead and pass it out? We have copies, so is it okay if they pass it out? Okay, thank you. So, yep, we'll get it passed out while you explain it to us, please.
All right, so my amendment here is on line 31, would basically add and change this here, where an offender who is required to register for a sexually violent crime as defined in KSA 244902 and amendments thereto may not petition for relief from registration requirements. This is specific to those offenders who are sex offenders of children.
Okay, so committee will have questions now. Representative Vaughn.
Thank you, Madam Chair. So I was thinking that in the hearing, it was clarified by one of the representatives that the the existing language did not, was not inclusive of is aggravated the right word? Aggravated crimes. So I was thinking that this would already not, like, this was already part of the law. Is this adding something to it, or is that encompassed by that? Am I making sense?
Yes, Madam Chair and Representative, I spoke with the revisor to clarify on the sexually violent crimes and crimes in general as that related to children specifically to get clarification. And we're talking about sex crimes with a child. We're talking about an adult who knows right from wrong and that they are doing something sexually to a child. This would encompass those who are doing this with abuse of force, as well as those who just know that this is wrong to do this to a child. So it encompasses all children and sexual abuse crimes against children.
Oh, which I agree with. I was just thinking that the existing legislation already covered that. So I just wanted clarification from maybe the revisor if that was the case, or if this does add something.
Jason, could you give us a little help on that? Thank you.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So it's an interesting dilemma from a drafting perspective because there are so many people affected by the retroactivity. So the question was kind of, are there any affected by the retroactivity that would not have registered for one of these offenses, but were required to register because of the 2011 changes? And there's an outside chance. I'd have to look at specific cases to figure that out. The other potential option was those who may have been required to register for 10 years for one of these crimes. And that seemed like more of a possibility, that someone may have had their time period extended because of the 2011 changes. And I apologize to the representative. I did not narrowly tailor it to just the child crimes. They are all covered by sexually violent crime because we kind of were looking at, where those crimes fall, right? If you look at the list, which I included as part of the amendment, we're talking ag indecent liberties with a child. We're talking indecent solicitation of a child. We're talking sexual exploitation of a child, right? So these are those crimes, but there are a couple others in that sexually violent crime list that do not necessarily require a child victim. So that might be something I need to tailor a little bit more if that is all you want to cover. But essentially it was, the point of this is to, if for some reason a sexually violent crime, a person who's required to register for a sexually violent crime is able to petition under the new rule, this would make clear that they should not do that it should not be allowed. And I don't know how many there would be. But I think we heard that there were a couple people who thought it would be covered by this new rule. And the idea might be to make clear that those folks should not be able to petition. Not to speak too much for the proponent.
Representative Barth, did you want to say something?
Yeah, I
And
just want to
I know
say
there's a
that
few
I
questions.
feel like that's unclear then based off of what the revisor is saying, because I had very specific directions of it to address only those folks who have committed a sex offender crime with a child to be excluded from coming off of the registry specifically. So does it need to be rewritten?
Madam Chair, I think I could do it on the fly pretty easily because we have the language in 224902. I just didn't do it this morning. I could do it really quickly if you'd entertain that. So.
Okay, why don't we see what you come up with? But we can also postpone, if we needed to just, the working of this bill, we could, not that we have a lot of days left, but we can figure it out. So there's a couple of questions, And so let's see what those questions are. But Jason, if you could kind of think through it a minute, but then if you would like more time, then, we could wait on the working of this bill. Representative Bohai.
Thank you, Madam Chair. What is the definition of a child, please? I'm being serious.
Is that in
believe
there,
it's
Jason?
less than under 18.
Under 18.
Then I will not support this amendment.
Oh, what do you want it to mean, Representative Barth? That's the question.
For child, for any child being under the age of 18.
Okay. Representative Osman.
Thank you, Madam Chairwoman. Before we even got to the discussion of the question of what we're dealing with, I looked up, KSA 22-490-4902. Sexual violent crime includes things like criminal sodomy. It includes promoting the sale of sexual relations. And a number of other things that have been repealed. So it's very difficult to actually research that because they've been repealed, but it's possible that they're still on the books as far as people have been convicted of them. So it would apply to them, even though we can't look up what the definition fully is. So there's a question there. The second thing is, I guess the second part is we heard testimony from people that we didn't get into specifically what their crimes were. We didn't ask those questions. But the point of this is, as heinous as those crimes were or could have been, number one, some of them have changed. And number two, some of them have the opportunity to change. And I think that that's what the goal of this legislation is opportunity to change, not guarantee to get off the list, just the opportunity to get off the list. In the same way as parole. Parole is not guaranteed, but you at least have the option at a specified period of time, unless under very specific circumstances where there is no possibility of parole, you have that opportunity to ask for clemency from the parole board. That is the same thing that we're talking about here, is just give that opportunity. And I don't see that this amendment as congruent with the nature of what we're trying to accomplish with this bill.
Thank you. Representative Lewis, did you have a question? Okay, I thought Representative Barrett.
Thank you, Madam Chair. And I guess to also provide some clarification, so the list I had provided was based on the research I found of, and my laptop just, there we go, who was under the 10-year registration requirement back in 2011. And call me out if I'm wrong, this is just information I found online. It was indecent liberties of a child, but this was the non-aggravated version, criminal sodomy, and they have to be 16 years of age or older, but not 18. I think when you get into aggravated, you're going to see in a lot of these crimes either under that or under 14 specifically. And then you go to non-aggravated indecent liberties for a child, lewd and lascivious behavior, as long as it's not under 16, and sexual battery. I don't know if there was a different requirement that I missed, but I would like more research done too, because if there's anything that I miss and it's under 14, I think the research has shown that if an offender is going on someone, especially if they're prepubescent, that person's not going to change. Their psyche isn't going to. So I would like more research done too.
So if I understand what you're saying, the folks who would have gotten 10 years rather than 25 years or the rest of their life on the offender registration, those are the crimes that you just mentioned. Those were the 10 year that those people could have been caught in that retroactivity. Is that what you're saying?
From what I could find, yes.
From what you could find, okay. Representative Vaughn.
Thank you, Madam Chair. What was that statute number, just so I make sure I understand?
Yeah, well, these were just crimes I found for 2011, so I'm not sure what updates have been done, but I can just, I can read the statutes these are the ag. So I'll have to get back to you because there's a bunch of different statutes I've got listed here.
Okay.
Thank you.
Any other questions, committee? Sorry, Representative Carmichael.
Couple of, pardon me, a couple of observations. You know, it's always difficult in the face of allegations of crimes against children to say anything other than hang 'em high, hang 'em higher. It's real easy to get into that mode, and I understand why people feel that way. There are also, though, people who, not going to identify who it is, no relation of mine, but you know, a boy who's 18 years old who literally climbed in his 16-year-old girl friend's window, and he's registering for life. And I think Representative Osmond makes a good point that this entire scheme is not a get out of jail free card or a cancellation of the requirement to register. It's merely an opportunity to go in front of the judge and say, I made a one-time mistake. I've been through treatment. I've perhaps been in prison. I've been fined. I've now got a family. I got a job out at the aircraft plant. I need to get a security clearance. I can't get one because I'm on this list. This isn't about a blanket dismissal of the requirement for offenders to register. This is about giving them an opportunity for this very limited category of people to go in front of the judge and beg for mercy, clemency, if you will. Sure doesn't mean it's going to be granted. But I think we also need to realize that if we're going to adopt an amendment to this bill that the reviser is hastily drafting while he's trying probably to answer other questions or at least keep track of the debate, and we have members who are wanting more research on this bill to know what it really does, I really think we ought to take the chair up on her offer to come back Thursday when we've got a good work product that we can all stand behind of, yay or nay. But right now, we don't know what it really means. The reviser's working on the fly. This is an invitation to make mistakes that could embarrass this committee. Thank you.
Representative Barth.
Thank you, Madam Chair. And I am in agreement that I think if we had a little bit more time, I would like for the reviser to have a little bit more chance to review. When I spoke, we talked about, I think what you mentioned is the boyfriend climbing into the girlfriend's window, right? He calls that, it's kind of got a terminology of a Romeo and Juliet. My intent is to not have those folks be part of this. It is truly those people who are abusing sexually a child, whether it is aggressively through, I just forgot the legal language, aggravated, yes, or non-aggravated, both of those. I cannot, in my head, get out of my head that aggravated or not, you were talking about a child who has no strength compared to an adult human who chose to do this. So that is my intent, is just those folks in that category and how narrowly we can write that they do not have the ability to get off the list, which in turn would mirror current statute.
Okay, I think that's great. I think we'll stop working. We don't have a motion. We don't have to, do anything official. I think we've had a good discussion. We'll give Jason a little bit more time, but this will be on our list on Thursday to come back to. Okay, thank you. All right, we're now looking at House Bill 2183. And let's start the discussion on that one. Representative Barrett.
Thank you, Madam Chair. And would this be the time I could have my amendment passed out and talk about it? Great, thank you.
If you could explain it to us too.
All right, thank you, Madam Chair. So since our last discussion, I've spoke with the representative, now senator in Utah that has their existing state law. We've also gone in further discussions, Representative Lewis and I, with an individual who works in federal law enforcement, was able to give us case examples. The two things we found, first on the federal side, they are prosecuting cases that are 100% AI generated cases. And then secondly, when I spoke with Utah, the representative there stated that they had the same conversations we did, where, you know, there was this case law from, I believe, 2001. There was in a concurring opinion that, hey, as technology changes, this is potentially subject to change. And also since then, there's been other case law, not specifically you know, going over this, but whether it be restricting the pornographic material, having the ID verifications we just passed in this state being upheld. So there's been indication that the Supreme Court is going to change. In addition to that, like I said, the federal government, federal law enforcement has had cases that have been adjudicated. And then we have the Utah law. So when I spoke with the Utah representative, he had mentioned that when they had these conversations, they decided to go and go with it. They thought that the Supreme Court was going to go with them on this. But even though he stated that, we still went a little more conservative. So I want to talk about the changes we made. First of all,
Just 1 second.
Yes.
I just want to remind, does everyone know what bill we're talking about? Because I did not have the reviser give us a quick review of what the bill was, but we all know. Okay. All right. Thank you. Go ahead.
Yep. Thank you, Madam Chair. So in Section 1, you'll see that we added possessing any artificially generated visual depiction with the intent to arouse or satisfy the sexual desires or appeal to the prudent interest of the offender or any other person. When you continue, you get to this, the next section, and this will be on the second page, the box on the side. We now talk about obscene and we define obscene. So why, when we already have an obscenity statute, would we want to bring obscene over into this statute? The reason why is obscene material under current statute, and when you have that first offense, the Class A misdemeanor, that should be completely different when you're talking about an adult than when you're talking about a child. If you have someone producing CSAM, child sexual abuse material, whether it be AI in whole, in part, that person is going to have an attraction towards children. He needs to be charged with a different crime that shows that. And so we're bringing in the obscenity, which if you have obscene material, that's not constitutionally protected. And then we go to number 6, artificially generated. So we give a definition, and that's artificially generated visual depiction, means a visual depiction that is obscene and produced through the use of computer software, digital manipulation, or other means that creates an image or video that appears to depict a child under 18 of age, shown or heard or engaging in sexually explicit conduct. Artificially generated visual depiction includes depictions that are obscene, and then this next part is really important, indistinguishable. So you've seen that in federal statute. So it has to look exactly like a child. We're not talking about cartoons. We're talking about AI-generated imagery that you can't tell if that's a child or not. So there's a few pluses to this. First of all, when a prosecutor's office finds CSAM on someone's phone, but they can't verify who that child is, then this allows them to still charge it. Now, if it's indistinct, if they can't ID who that child is, prosecutor offices may not be comfortable because you can't prove if it's completely AI or not. So as we continue, so indistinguishable from any real child, marked from a real child's image, or generated without any actual child involvement. If we go, we're now on section 2, but we're on page 4. You'll see we continued with including but not limited to such items in which the person depicted, once again, is indistinguishable from a real child, morphed from a real child's image, or generated without any actual child involvement. So again, you can't tell the difference if this is a real child or not. The current AI technology, as I testified to earlier when we first presented this bill, is so advanced now, you can't tell if it's a real kid. But then I also want to just point out the pretty obvious point is, how does AI know what a child looks like? How does AI know what a prepubescent penis looks like? I mean, that data has to be input. So either way, it's indistinguishable from a real child. When you look at section 3 on breach of privacy, nothing was changed there just because it already has to be, it has to match that identifiable person. So we didn't feel the need to add that indistinguishable part. But again, we are following what federal law enforcement has told us that they're doing currently. We're following what the state of Utah has passed in this last legislative session. And so I'm confident that this is a good amendment, and it'll help just provide some clarity for the concerns about cartoons or anything such as that. Thank you.
Okay, committee, what other questions do you have for the maker of the amendment? Representative Carmichael.
Thank you, Madam Chair. Actually, several questions about this amendment. First, as I understand it, with your amendment, this bill will only apply to computer-generated images. Is that, I see you shaking your head no.
No, you'll see there's a section A, which is possessing any visual depiction of a child under 18. And then there's a section B, so it's or. Section B, possessing any artificially generated visual depiction with the intent to arouse or satisfy the sexual desires or appeal the prudent interest of the offender or any person. So it's divided.
So I'm not going to do this, okay? But if I took out a paintbrush and started painting an infant having sexual relations with an adult, an animal, all kinds of other horrible things, would that be cognizable under this statute? In other words, against the law?
It's not indistinguishable from. So it has to be indistinguishable from a child. You cannot tell that that's not a real child.
So paintings, for example, that are obscene, they're pornographic, they depict terrible things, they're acceptable under this statute? Or under this bill or this amendment?
There's already the obscenity statute that would cover that. But in this statute, it's made clear it has to be indistinguishable from a real child.
The second area of questions concerns this Utah statute. It was passed comparatively recently, correct?
Correct. I believe, and I can bring it up, I believe it was 24.
And I think and I thought that legislative research, since the requests were made in committee, was going to distribute the results of their work to us all, but I don't know if we have what they intended to distribute or not. But the Utah statute, it's not been subjected as of yet to constitutional review.
Yeah, according to the now senator that I spoke with, they have had no constitutional challenges. And I'll just add that their definition is artificially generated and depicts an individual with substantial characteristics of a minor engaging in sexually explicit conduct. So again, ours is more conservative.
But you understand that there's a difference between, quote, no challenges and a court opinion that approves and says their statute meets constitutional muster.
I'll acknowledge that, but I think adding the obscenity portion also assists.
And my third question is, I call your attention to the recent authority out of the state of Indiana, Greco versus State, October 4, 2024, their Court of Appeals there, where a statute doing the same sorts of things we're trying to do here, the court applied the federal authorities and said, unless it depicts an actual child, it's constitutionally protected. How do you reconcile the Utah decision, the non-existent Utah authority, with the only case the revisor's been able to find on point, and it says what you're doing is a violation of the Constitution? How do we reconcile that?
Well, I haven't reviewed that, and I'm not sure if it also includes the definition of obscenity, which I believe helps us there. But by the sounds of it, it sounds like you're talking about a state appeals court that wouldn't.
State appeals court applying the federal law, the precedents in Farber, the precedents in Wilson, the precedents that we discussed just a few days ago.
Yeah, well, each state Supreme Court's Supreme Court's going to say something different, but we're confident based on what the federal government is currently doing, and has adjudication on, as well as
based on a conversation you've had with some friends.
In addition to them sending us cases that have been vetted, they've sent us actual case
cases?
numbers.
Because that's what I've been looking for, is the case law that says this meets constitutional muster. Where is it? Because we can't find it. We've looked. All what we can find shows that it's not.
Okay, thank you for your comments. Would you like to reply, Representative?
Yes, so these cases were sent to both myself and Representative Lewis. I believe he wants to speak on the matter.
Representative Lewis.
Right, so let me just try and summarize what I believe we were initially presented with and the substantive change that's been made. Initially, the bill provided that if you had an artificially created, AI-created visual depiction of a child, unknown child, that constituted CSAM, which is for children's sake is basically, did it sexualize the child? The original bill said that would be a violation of criminal law under statute, under Kansas law. I agree with the assertion by Bidds and Representative Carmichael that at least the current state of the law under Ashcroft and progeny, if you just read those cases, you would say that that would be in violation because there was no identifiable child. And I understand that actually that's what the Utah statute does. So it's pushing the law beyond what it currently is, and their argument is time has elapsed since 2002, and artificial generated CSAM has, changed, and therefore they think once challenged, it will be upheld. What Representative Barrett has done is to make this a more, quote, conservative law, one that I do believe passes constitutional muster under current law. And the reason for that is what the amendment does is it says that in the case of a artificially created visual image of someone who looks like a child, even though you can't identify that child, it's nonetheless criminal if it's obscene. And I would just say, think of it this way. Under adult pornography, for it to be past constitutional muster to regulate it or to restrict it, the pornography has to be obscene, which is a very high standard. It has to be really beyond. Under child pornography is judged by a different standard. Basically, are you sexualizing a child? It doesn't have to be obscene to be to criminalize that. But as I said, where you can't identify the child, the law seems to be you can't criminalize it under the normal standard of child pornography. And once again, what we did here is we raised that standard. So the artificially created visual image has to be of a child or something indistinguishable from a child, and it has to be obscene. And I think that passes constitutional muster, and I therefore am in whole support of the amendment and the bill.
Okay, does anyone else have any questions for the maker of the amendment? Okay, just one second. Would you like to move your amendment, Representative Barrett?
I'll move my amendment.
Is there a second? Representative Sweeley seconds. Okay, now we will have discussion on the amendment. Representative Carmichael.
So far, we've expressed two different approaches to the problem that's been identified. The first is what we see in the base bill. The second is an improvement from Representative Barrett. And the representative of Garden City and I might disagree as to whether the Barrett amendment is within or without the existing law. Certainly, if the law changes in the way that the representative predicts, then it'll be acceptable constitutionally. It's an arguable question, I believe, right now under the current state of the law. There's a third alternative, and that is we stay within the safe harbor of the Ashcroft decision, the Farber decision, the Wilson decision, and on down the line, the progeny, as counsel refers to. And that amendment lays at the desk of the reviser because I asked for it. And it simply says, or simply modifies the bill to say it has to be an image of an actual child. It can be a partial image, a full image, but it has to be based on an image of an actual child. Why is that important? One, if it's an actual child, then if it depicts physical abuse, there's been a child harmed somewhere, and the people who possess it damn well ought to go to jail. The second possibility is that someone has appropriated a child's image, taken their Facebook picture, and put it on an obscene or a pornographic photograph, which also damages a real child. So we know we can do that within the Constitution. The question is, do we want to push the limit here? Maybe folks think that's the right thing to do, but so far, we don't have a single case that we can find in these United States that says what's proposed by the original bill or the Barrett Amendment is within the Constitution. I think we're much better off to stop this problem with the tools we have. And if at some point in time, the United States Supreme Court extends the doctrine in Ashcroft, and I will grant you that there are some justices who've suggested that they might do that, particularly in the dissent in the Ashcroft case. But unless and until that happens, we can pass a constitutionally secure law by amending it to an actual child, and we can put a whole lot of bad people in jail, or we can go down a different road and try to push the limit and find we have a statutes that are unconstitutionally vague and or violates the current law, and we have arguably no statute at all at that point dealing with computer-generated or AI pornography involving children. I think the better policy approach is to stay within the safe harbor of the existing law. That way we can successfully prosecute people rather than trying to expand the law here in Kansas, and who knows what will happen if we go down that road.
Representative Barrett.
Thank you, Madam Chair, and I do appreciate the representative's input. Yep, different view, absolutely. What I would argue is, there are real victims. As you went through our testimony, not just from myself, but from other prosecutors, there have been studies as well as experts who deal with these offenders every day that show that people who are in possession of this have, one, more likely than not, through admission, gone hands-on with a child, or two, they're going down that barrier, that cycle, where that barrier between going from that CSAM to a real child, that barrier continues to go down. So real children do get affected. And then the second point I do want to point out is this statute will also help prosecution and prosecutors because, again, like I said, when they see material and they can't verify that's a real child, they just can't charge it. Through my position where I do assist with child exploitation crimes, they've tried to use our our facial recognition to identify these kids so we can charge them, but we just can't. And so this helps with that. Again, there's other laws in Utah. We also mentioned, I believe it was South Carolina or where their state was, but this, I believe, is a very good amendment. I believe this is going to resolve the issue that we have. Thank you.
Okay, thank you, Representative Barrett. Is there any other discussion? Representative Lewis.
Just want to respond. I don't think there's any question that as amended, this passes constitutional muster for the simple reason that it's clear under adult pornography that if it's obscene, it can be criminalized. And we're saying that this has to constitute obscenity. So as amended, this does pass constitutional muster, and I think it's clearly distinguishable from Ashcroft, and Ashcroft did not involve an obscene image. So I respectfully disagree that we're pushing the law with once this amendment is accepted.
Okay, committee, is there any other discussion? I'd like to go ahead and vote on the amendment unless someone else has something that they'd like to. Representative Osman.
Thank you, Madam Chairwoman. I want to try to understand one phrase in here that's listed twice, or generated without any actual child involvement. Can you help me to understand what that means?
Yeah, so AI can create an image that you cannot tell is the difference between a regular child now. it looks like a legitimate child, but they can't prove what was used to generate that. So like, although I did mention that there's all kinds of data that's input in AI so it can create those images, information that's way far above my head, because they can't prove that an actual child was used, they're not charging it, especially if it's completely AI generated. So this is just clarifying that any kind of child sexual abuse material, if it's indistinguishable from a real child, you can't tell if it's AI or not, then it would be counted in this amendment and in this statute, or this bill. Thank you.
Okay, thank you. I mean, from my understanding, there might be 3 different ways that AI can be generated. One is from actual child porn that then gets changed into other type of child porn. The other is from innocuous images that then gets morphed into child porn. The third way would be if AI you could just say, create me child porn, and it did it whole cloth with no other factors whatsoever. I don't believe that that's how AI is created. It draws from its data set, but that would be the third way, and that would be generated without child involvement, as opposed to the other 2, which actually have child involvement, whether you can prove it or not, or whether you actually go through the steps or not. So I guess my concern is if there was a way that AI could create it of whole cloth, that might be indistinguishable from art, which, like it or not, becomes protected under the First Amendment. So that is, I'm just struggling just with that portion of it in trying to determine where AI is getting its information from.
In the technicalities of AI, that's just way above my head. I'm, not being a computer AI guy, but you have to remember this is obscene in nature, which obscenity, as the Representative Lewis had stated, is not protected. And then in addition to that, it's indistinguishable from a child. So it has to be these obscene acts of what you can't tell is an AI-generated child. So I don't see the argument on that, especially when it's obscene in nature. Thank you.
Representative, would you like to close on your amendment?
I'll close. Thank you.
So committee, you have heard the amendment, the Barrett amendment, seconded by Representative Tweely, I believe. And all those in favor, say aye. Opposed, no. The ayes have it. We have passed the amendment on House Bill 2183. What other discussion do we have on House Bill 2183? Do we have Representative Ward?
I'd like to offer a very simple amendment.
Very good. Thank you.
2 words.
Would Representative Ward, would you like to explain your amendment?
Yes, I would. My amendment would include the word cable services on page 6, line 9, under the section that outlines who this section does not apply to. This is at the request of Cox Communications and the cable industry. When the statute was originally written, it included that it didn't apply to telecommunications carriers or radio carriers or others. This simply clears it up and includes cable services. It also aligns the exemption language with similar exemption in other states that enhances the exemption to avoid unforeseen consequences to entities not intended to be captured by this law.
Okay, committee, do you have any questions for the maker of the amendment? Representative Carmichael.
Just to make sure I'm clear, this is saying that a cable service, as defined in the federal law, is not responsible if it's used to promote, send out hundreds of thousands of images of children being abused, that they are without any liability, yet they make a lot of money doing that. Is that the intent?
Yes, and I'll defer to Megan Bottenberg, who's here from Cox Communications.
I'm not sure, Madam Chair, that we take testimony from the floor once it's been closed. I think we're stuck with what we got.
I would say, Megan, if you'd like to come over and talk to Representative Ward, you may. while we're waiting for that, do we have any other questions? Representative Barrett.
It's more of a comment, if that's okay, Madam Chair. I'm pretty sure this is very common in exploitation. The internet service providers, ISPs, including this cable company, they're not monitoring what's always going through their cables. So I see it as a friendly amendment and just standard procedure. So thank you.
Okay. Do we have any other comments or questions on the amendment? Representative Barth.
I just have a clarifying question based on what the representative just stated. Is it common then, I don't know, cable companies, et cetera, promote pornography of children? Is that normal?
And the revisor can correct me. I don't believe this is about them promoting anything. This is just that it's going, this data is going through their facility. And so as it goes through, they're just saying they can't be held liable for that because they're not monitoring it. But again, the revisor can correct me if that's incorrect.
I have a follow-up, Madam Chair.
Yep.
Do they monitor other things going through? And, you know, I guess if we're going to make this statement, I just want to clarify, are they monitoring other things that go through?
And I honestly wouldn't know.
Okay, Representative Ward, do you have an answer? For
Yes, I mean, their stand is they're simply the transport service. So they don't sit and monitor everything. It's just, I guess,
yeah, no.
I don't know how much further to say on that. I mean,
okay. Yep, Representative.
That answers your.
Representative Carmichael.
Thank you, Madam Chair. And I want to be clear. I have voted in favor of immunity for cable companies and the like on multiple occasions before, and I'm probably going to support this amendment. But someday, sometime, we have to think about the fact, I shouldn't say the fact, but there's a number of fairly reliable pieces of data that says a very high percentage of internet traffic between the United States and Eastern Europe is pornography. And the only way that gets here is if I pay cable AT&T or Cox or whomever it is to have access to that flow of disgusting trash. And I'm not going to fall on my sword today. But we know that our attempt to keep children under 18 away from pornographic sites has failed. I attested to that earlier. All you got to do is just go on Google and type it in, and it'll take you to listservs, and you'll find all kinds of failed examples. And it's going to keep failing so long as everybody involved in this chain of commerce is in some way held responsible. And I don't know how to do it, but I think it's a problem, and this just perpetuates it. I'll still be voting yes on the amendment.
Representative Lewis.
So I just want everybody to mark their calendars. I agree with Representative Carmichael. but just to add to his comments, I mean, you'll see in the law, it references 47 USC section 230. Yeah. That law has been discussed ad nauseum for probably the last 10 years. There's litigation about it. The cable companies and all of them, obviously, basically creates immunity for them in these circumstances. I disagree with that for the reasons that Representative Carmichael suggested, and I think the law 230 needs to be changed. But I think we run into a supremacy clause problem if we try to do it here, and I think this opens up a huge issue that this committee's not at the moment ready to take on. So like Representative Carmichael, I will vote in support of the amendment simply because it's consistent with current law. But I also agree that it's an area that really needs some very serious consideration down the line.
Representative Barth.
Thanks, Madam Chair. I just want clarification. So we're basically saying that local exchange carriers, telecommunications carriers, and now cable services would be excluded. So they have this level of immunity. And I think I think this isn't, I'll also vote yes for the amendment, but I too echo what the previous two representatives have said, is that I think this hands washing of us being innocent here is probably due for that to be looked at, but on another time. Thank you.
Okay, thank you. And so Representative Ward, I'll just ask you just to clarify that you were just adding a cable service. We already are saying exchange carrier, telecommunications carrier, radio comm carrier, interactive computer service. It's just adding this one other way that we get things on the internet.
Madam Chair, correct.
Okay, thank you. Okay, is there any other discussion? Would you like to move your amendment?
I move my
I'm
amendment.
sorry. No, she's just now moving it. Okay, sorry. And
Move my amendment.
who did I hear say I'll second? Representative Bourgeon seconds. Representative Ward makes the amendment. Representative Bourgeon seconds. Okay, any other discussion on the amendment? Okay. Yes, Representative Goddard.
One word of caution, never say it's simple.
Yeah. Good to know. Good to know. Thank you. Okay, so would you like to close on your amendment? You did close. Okay, sorry. Thank you, audience. Okay, so you have heard the amendment to House Bill 2183, the Ward amendment. All those in favor say aye. Aye. Opposed, no. The amendment passes.
Madam Chair, I'd like my affirmative vote on the Ward amendment recorded.
Okay, Ward amendment, yes vote recorded. Anyone else? Okay, thank you. All right, committee, what other discussion do we have on House Bill 2183? Any other discussion? Representative Williams.
Sorry, there's two Williams on the Commerce Committee. Thank you, Madam Chair. I move House Bill 2183 as amended favorably for passage.
We have a second to that bill. Representative Ward seconds. Okay, discussion now on the amended bill. Representative Carmichael.
Thank you, Madam Chair. I explained in the context of the Barrett amendment why I can't vote in favor of the legislation in its present form. I believe it to be one of very questionable constitutional, very questionable under the Constitution. And the sad consequence is that when we pass overbroad, vague, or statutes that are contrary to the Constitution, we run the risk that a court may take a bigger swat at it than just as applied, meaning in this particular case, we're going to say it's unconstitutional. We run the risk of losing the entire statute. And I think the better approach is to let Utah and these places establish the law so that we know what we are doing will withstand constitutional scrutiny and will result in people being put in jail, not result in additional litigation and perverts going free. So I'll be voting no. Thank you.
Is there any other discussion on House Bill 2183? Sorry, Representative Barrett.
Thank you, Madam Chair. And just to again clarify, this is more conservative than the Utah law. There's we're adding the obscenity standard, which, as Representative Lewis has already mentioned, is already met, he believes, constitutional muster. And so with that, I really ask for everyone's support on this bill. Thank you.
Any other discussion? Okay, Representative, would you close on your amendment?
I close.
Motion.
I close.
Thank you. Okay, committee, you have heard the motion to pass House Bill 2183 out favorably for passage as amended. All those in favor say aye. Aye. All those opposed, no. So the ayes do have it. It will be passed. Representative, would you like your
I'd like my negative vote
no
recorded.
vote
Thank you,
recorded?
Madam
Does
Chair.
anyone else want a vote recorded on House Bill 2183? Okay, that's great. Okay, committee, we are not meeting tomorrow, even though I tried. I talked to the majority leader and said, could we meet anyway? And he said, no, you may not. So we're not meeting. I will let you know that We have two bills that we had two bills we were going to hear tomorrow, House Bill 2359 and House Bill 2323. We will go ahead and hear those on Thursday. Thursday was pretty light. I left it light, so thankfully that may be okay. We will also go back and work House Bill 2173. That was the one, the Offender Registration Act, that we needed a little more time on. There's another one, 2134, that was on today's docket, but we decided not to work it because they weren't ready. And that's the one about open records. There's a chance we will also work 2349, which is scrap metal, 2357, which is the eviction bill that we heard yesterday, and possibly HCR 5008, which is our rules and regulation resolution. So there's the plan is hearing 4 bills and possibly working 5 bills on Thursday. Thank you, everybody, for your great work. And have a good day tomorrow and be safe. And bring dinner. Okay, yeah. Okay, thank you, everyone. We're adjourned.